Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Brian Vicks, one of our talented attorneys at Cooper's, we will be discussing considerations when representing multiple clients in the same case. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Brian, welcome to the show.
Thanks for having me.
My pleasure. Today, we're talking about representing multiple clients in the same case. Have you had experience to deal with that?
I have, yes.
Without breaching any client confidence, can you outline a little bit of your experience in that regard?
As an attorney, I have had a few cases where I have represented husband, wife, or a minor child with parents involved as guardian ad litems, and a couple other cases where there have been a couple plaintiffs all in the same action. As a paralegal, I was a paralegal on a case where we had in excess of 16 plaintiffs on a case at one point in time in a what we would have called then a cluster action.
Cluster action. Usually I hear the word cluster with something else. I'm curious about that. I have not heard of cluster action before. What is a cluster action?
I think that a cluster action is a loosely defined term that calls a case that doesn't qualify as a class action, but that has more than a few individual party members of a growing theme for a cause of action.
Interesting. This is what I love about the law. You're always learning something new. In the area of representing multiple clients, what are some of the concerns that you have as an attorney when a case like that presents itself?
The obvious red flags are confidentiality and dealing with getting everybody on board, knowing the direction that the case is going to have to go and where we're going to be taking it. Those are the big red flags. But I think that once you start to get into the nitty gritty of a case, there are significant things that are going to be coming up. Particularly the more plaintiffs that you're dealing with in a case, you are going to be dealing with more opinions, more people that you are going to have to get on board. And on top of that, if one person happens to, say, pass away, they're going to have successors in interest. And so now you're going from one plaintiff to 2, 3, 4 successors in interest that all have a interested stake in this cause of action, which now you're going to have to deal with even more people.
In the category of addressing confidentiality, why don't we go down that path first? Say you're representing multiple clients and you're being asked at the outset, hey, you're considering representing me and a few others. What happens to confidentiality if I tell you something in confidence?
There is a potential that I can't maintain confidentiality having multiple plaintiffs, multiple clients representing one action if you're talking to me about something. If it's going to affect other parties, there is a potential that that is a conflict for me.
And can you give me an example of how that might play out?
If you were a husband and a wife, and at the onset there was a loss of consortium claim, and then later on down the road in the litigation, you as a married couple decide to separate or to divorce, now there is a actual conflict between you and your ex-spouse or the individual who you are separated from or are in the process of getting a divorce from.
That makes sense. In that scenario, let's say you're preparing the husband for deposition, and the husband says, look, I'm concerned that this may come out in terms of, whether I've been followed or what have you. I need you not to tell my spouse I've been having an affair. How do you handle that?
That's a conflict. And at what point in time you have to abide by your ethical duties and make sure that you're handling the situation correctly. I can't be keeping things from people who are on the same cause of action that I'm representing at the same time like that. I can't keep it quiet all the time. And at which point in time, if this becomes a conflict, now I'm going to have to get another lawyer involved and I'm going to have to excuse myself from representing both sides.
And I think one of the things that we frequently see, and we'll see it in either a knowing waiver of conflict meaning a written document that people sign when they're agreeing to be engaged by one lawyer for multiple people, is they'll describe what's known as a potential conflict of interest versus an actual conflict of interest.
Correct.
And you just outlined, I think, a potential conflict is if a husband and wife have the same lawyer for the claim and the loss of consortium claim, there's always the potential if a fissure arises between the husband and wife. It becomes an actual conflict when there's an actual fissure where they're getting divorced or they're having some form of dispute. And is it at that point that they have to get another lawyer?
Yes.
Okay. Are there any written requirements for disclosing conflicts of interest?
As my ethics professor would say back from law school, most of the time, written and informed consent will cure all. But for potential conflicts, you do need to outline what the potential of conflict is going to be. You need to have both parties or all parties involved informed and written and give you consent to proceed representation with that knowledge and understanding.
That makes a lot of sense. Do you have a best practice recommendation in terms of whether that is something that is baked into a form representation agreement or a separate document?
I think that both should happen. I think I've seen fee agreements and representation agreements where it has been included standardly. I have also seen it be very clear at the onset that there is a potential for conflict and an attorney go above and beyond and make sure that there is a separate additional document just to essentially CYA and make sure that you have everything correctly, all your I's dotted and your T's crossed.
The other example that sometimes comes up in potential versus actual conflicts of interest is the situation where one learns there is a limited pot of available compensation. Have you had that situation?
Yes.
And how do you handle that?
It becomes a very uncomfortable conversation. People tend to not always handle conversations with money the best. And when you start saying there are limitations there's no way around saying it, but sometimes people tend to get greedy and it causes conflicts because now there's an adversarial issue where people want more money and you have conflicting interests. When there's a limited amount of money and you can only have $100,000 going one way, where's it going to go?
One of the recommendations that I got early on in my career was to address this head on at the beginning. And it's whether one is representing all of the potential clients in one case or whether it's with multiple lawyers, that there be some form of agreement about how to divvy up the proceeds if the proceeds end up being limited. And to that effect, an agreement to mediate, and if not mediate, to go to binding arbitration to divvy up limited proceeds. Have you come across those?
I have at our office.
Well, I think I've arrived at that through the pain of having to have an argument at the end as opposed to it being theoretical at the beginning. So when it's theoretical and theoretical money, people tend to be more open and more willing to say, yes, this is something I'm willing to do. And to describe how that looks like, it's an agreement that says, if it turns out that the money is limited, we will agree to mediate the outcome of the pile of money if we can't agree to it. And if mediation is not successful, then we agree to go to binding arbitration. And I recognize that my lawyer can't represent all of us. I will either get separate counsel or I will represent myself for that binding arbitration process. And in doing so, you have built the frame for an inexpensive dispute resolution process. And when you do it at the beginning, people will say, oh yeah, that sounds perfectly reasonable. When everyone realizes at the end that there's only $100,000, it becomes much harder to enter into that agreement. And I think that's why we've approached it that way. It's just easier to do at the outset. With the problems that sometimes arise from potential conflicts of interest going into actual conflicts of interest, what reasons would you outline for a client as to why it is useful to actually have joint representation?
Cost. One attorney probably is also going to have a better understanding of the case, easier to communicate with, easier to have a relationship with. If I'm one attorney and I'm handling two individuals that I'm representing, it's easier for them to get into communication with me. It's easier to coordinate depositions. It's easier for one office to handle discovery. And it's going to be a better outcome typically because it gives me a larger amount of capital to negotiate on behalf of two individuals versus having to negotiate for one person, as well as I don't have to get another plaintiff's attorney on board. I might not see eye to eye with another plaintiff's attorney on the evaluation of a case, where we're going. My client might have a stronger claim in the case versus the other plaintiff. Those are considerations that you have to take into account.
You brought up how working with another lawyer or working with other folks can create problems in terms of communication. Have you seen situations where the failure to properly communicate or work with outside other counsel has resulted in there being problems in the case, and that people are saying different things about how an incident happened?
Yes, I've seen different stories, different reenactments, different relays of information regarding the facts and timelines of how an accident might have happened. Another thing that I think that I see a lot of time is it creates a lot more air for clerical issues or administrative issues, not scheduling or forgetting that a depo is happening. Having to coordinate two attorney offices with a doctor with the person who is noticing the depo is a lot more complicated than only having to deal with two attorney offices and one doctor, when a doctor isn't going to give you a very large amount of time to schedule a deposition to begin with.
You talked about costs. I want to dive into that a little bit because I've seen different firms handle costs different ways. There are costs that are common to the case, and there are also ways to deal with the allocation of those costs. My recommendation typically to clients is to have those joint costs shared on a pro rata basis, meaning in the fee agreement in the beginning of the case, if we're going to spend $100 on the case and you get $70 and she gets $30, that the client who gets 70 pays 70% of the costs. Have you seen firms handle it differently?
I have seen firms handle it that way. I have also seen firms handle it where the client's costs are the client's costs, and it does not matter how much they're going to get, but that's just costs $400 for a copy of your deposition transcript. It's going to cost you $400. I don't think that that benefits them, but I have seen it done that way.
Okay. Then there's also the breaking out of things that are costs that are specific to one client versus another client. And here you might have a situation where we have that loss of consortium example. One client may have a lot of medical records, and ordering all those medical records can get very expensive. And another client has zero medical records, and how you allocate those individual costs to each client versus a joint case cost. How have firms that you've worked with handled those in the past?
I have seen one net where if it's a couple and they have made the agreement that they're just going to share equal in the cost, it's not a big deal for them as long as it's in agreement in writing. They understand what's going on. I have also seen situations that we have had to take particularly detailed notes, knowing exactly where each penny is going in regards to each plaintiff on each case, because that is where the pot is going to have to be reimbursed for our costs from.
And on the particular approach, starting at the outset, opening in essence 3 matters, which sounds silly, but 3 matters for 2 people. One for the joint costs, police report, an expert on liabilities, someone who's a proof piece. And then the 2 others, one for client A, one for client B. And then it gets allocated very easily at the beginning, and it's much easier to close up the case at the end.
Correct.
The final thing to ask you about is preparing individuals for deposition. Do you typically prepare them in a joint session?
I have done both. I have found sometimes doing both is helpful as long as there's nothing that I need to be aware of and there isn't a confidentiality or a conflict. I have also found that sometimes doing it individually is better for them because it gives them a sense of having more private one-on-one time, building their confidence, and doubling down, basically knowing exactly what the facts are.
How do you approach that then? Is it on a case-by-case basis?
It would be on a case-by-case basis. Sometimes also, if it's a husband and a wife, for example, they might prefer to do it together at the same time. It might be more convenient for them on their schedule as well. Raising children, working, especially here in the Bay Area, those are things that you have to take into consideration too. And something like a depo is largely determined by the amount of prep time. And you do a good amount of prep, you prep the clients, you know the facts, you're prepared for it, the more time you put into that, more likely your depot is going to go better. And sometimes doing that together, you have to make sure that you put the time in. And people that are here in the Bay Area, it's expensive to live. People are working, people are raising family. They don't have a whole bunch of time. Sometimes you have to do it together.
Also, when they're together, if there is some sort of an issue, and I think of this because it's come up for me more than once, where there may be a disagreement on the loss of household services analysis. Here's what I mean by that. Someone may think that they do more around the house than the spouse thinks they do. And having that come up in a joint session so that it is in agreement when they're both asked the same questions about that is an easier way to head that off at the pass.
It can. I'm also slightly scared that that might result in some therapy that might be needed afterwards because husband and wife might have a disagreement about what they think they're going to be doing.
As it has come up, as long as I can make sure that people are hearing each other and we can hash through it and make sure that people are on the same page, I find that that's going to lead to a better outcome. Are there other things that you take into account when having that pro-con conversation with clients on joint representation?
The logistics, coordinating, making sure that they're on the same page. And I think setting case expectations are important, that people have an understanding of what they are looking for, what we think, how we think we can help them, and what we see the end results being in some kind of form of a ballpark. Everyone being on the same page and being transparent and good communication, I think, is what's the most important thing. And I think that that is probably the most pro thing about jointly representing people. It creates less of a barrier of communication, less of red tape that you need to go through in order to get an answer from an attorney.
That all makes sense.
The one other thing that I would say is when you're representing multiple people, I think the logistics are very important. If you represent 5 people and you're going to trial, trying to coordinate 5 families or their members or witnesses for those people, it's going to be an administrative hurdle, and you are going to need significant staffing help in order to make sure that you have people showing up where they're supposed to show up, do what they're supposed to do, appear for their depositions like they're supposed to. And the more people that you add into the mix, the more complicated it becomes, the more time consuming it becomes. You have to learn how to be able to handle individual people and know how they're going to take a request. And there's a very large human dynamic to representing multiple people in one cause of action that I think sometimes you lose that human person-to-person relationship element to the interaction.
So my takeaway from that is, while there may be more people to work with, one needs to recognize that this is not a cattle call, that each one of them is a human needs, and the willingness to work with them and their schedule to help them understand what they need to do and how to do it.
Yep. And how you address one person is definitely not going to be how you're going to address everybody else.
Other techniques that you've come across to work with multiple clients in the same case?
I really just think building a good relationship at the start. The sooner that you can get to the point where your client feels comfortable calling you by your first name and they ask you to call them by their first name, signals to you you're building those foundation blocks of a relationship of trust and communication. And hey, like, I really need you to call me back here. Like, we need to discuss this. I think those are probably the most important aspects of it.
If an attorney was to ask you, what have you found to be the best 1 or 2 things for establishing that rapport early on, that getting people to feel so comfortable as to call you by their first name, to be willing to pick up the phone, what would they be?
That's really hard for me to answer. For me, I think it's just being myself. I really enjoy interacting with our clients. I really enjoy building the relationships with them and talking to them, seeing how their day is, seeing what's going on in their lives. How are you progressing with your injuries? Like, are we making steps in the right direction? And for me, that's really natural. And I try to calm people down and understand that they're going through a really, crappy situation. How can I lighten the mood? And for me, I don't really have an answer to that. I think that that's just kind of my personality, is I like to talk to people and I like to warm them up. I would try and maybe describe that as maybe attorneys have a little bit better bedside manner, a little bit warmer ability of approaching somebody, a little bit more emotion versus sometimes lawyers tend to think things too analytically and take emotion out of it. Maybe be a little bit more emotional, tap into your heart a little bit more.
So you're saying help humans by being human.
That's a good slogan.
I will confess that sometimes when I get on the phone with a client, I will be so anxious to convey the information that I forget some of the basics. I usually remember it by the end of the call. And the way I have come to deal with it is to recognize that and say, oh my gosh, I'm completely lacking in humanity. I called you up because there was this issue in the case and I want to communicate it. I didn't even start with, how's your recovery going? Because that is important. How are you doing? And the nice thing I will say is they'll usually forgive me by that acknowledgement, but it's unfortunately, we sometimes just get so hardwired into that lawyer, I'm going to fix this, that the human element doesn't come forward. Anything else do you think people should know?
Just have a little bit of patience when you're dealing with a case with multiple clients. Sometimes as an attorney, I'm waiting for other things to happen. I'm waiting for some other responses to be responded to. I might not be able to give you a response immediately because there are other things that are coming down the pipeline that I'm waiting for a response for. I need to be in communication with a couple other people. So the more clients or the more plaintiffs there are in a case, sometimes it also does cause delays. So if I'm just working with one individual, put my feet to the fire. If I'm not responding to you, that's on me. Sometimes I'm going to need clients to be a little bit more patient, understanding that I'm trying to manage a few people here.
And do you convey that at the outset so that their expectations are set accordingly?
I try to, and I try to remind people at the same time as it's coming on. And I try to be very transparent with it. As an attorney, also, I need to recognize that people want fast results. People do want to be responded to. That might be hey, I received your email. I don't have a response for you. I will respond to you as soon as I can. And that might be the response that I have to give to them immediately. Hey, I'm sorry, I don't have an answer for you right now on this. I will get back to you as soon as possible. I received your message. I'm not forgetting you. You're not on the back burner. I will get back to you as soon as I can. I just don't have an answer for you right now.
Well, I think you raise an important point because sometimes the attorney approach, and this is one of the most common complaints to the state bar, my attorney doesn't get back to me. The attorney approach is to recognize they don't have an answer and to just not respond. So I think your way of handling that is wonderful. Well, thank you, Brian, for being here.
Thank you for having me again.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you handle multiple clients in the same case. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.